we're gonna get started. Just little ground rules. When you're speaking, you can take your mask off. Rest of the time, please leave it on. We ask if you can, you know, for some reason you can't, obviously take it off, but whoever's
What if you're
speaking.
listening? To leave it on, to listen.
When did you start listening? So that's what, just that, we just ask everybody leave them on unless you're the person actually speaking. And that we maintain social distance. Obviously, mom and son don't have to because they're in the same household. So you have to be 6 feet apart unless he wants to be. You know? What grade are you in?
I'm in eighth grade.
Eighth grade? Yeah, a couple of years he'll want to be. So I'm going to turn it over to Mary if we're live now, and she's going to introduce everybody, and then I'll take over.
Thank
As
you.
you know, she's okay. Go ahead, Mary. Counselor.
Thank you, Terry, very much. I just want to welcome everybody as the home counselor to Judge McDonough and indicate that he has my wholehearted support. I'd like to introduce his lovely wife, Melissa, his son, Bobby, and his witness, the Honorable Dan Ford, retired. I'd indicate to you that I have bronchitis. I'm homesick and am not able, I believe, to conduct a meeting without and coughing and interrupting. And rather than do that, I would turn this meeting over to my able fellow counselor, Terry Kennedy, who's been at this for a long time. Before I turn it over, though, I would just like to say that Ed McDonough, as an attorney, has been a colleague and a friend, and as a justice in the Superior Court, he was very well respected, very well liked. And I know that as an appeals court judge, everybody mourned his loss from the Superior Court. I also know that he did an excellent job and had a great reputation in the appeals court. And when he called me to have coffee, I was not the least bit shocked or surprised when he indicated to me with fear and trepidation that he would like to go back to Superior Court. Because above all else, besides being talented as a lawyer, having a great legal mind, having a great temperament, and being one of the most well-respected jurists that we have, I knew in my heart he was a trial lawyer. With that said, I think he thought I was going to say, no, absolutely not. Are you crazy? Forget it. And I said, let's go, Eddie, because I knew how much the trial court meant to him. So, Ed, you got my vote, and I'll turn it over to Terry.
Thank you, Counselor. We all hope you feel better.
Thank you.
All right. I'm going to start by introducing the counselors that are present. Counselor Jubenville, Counselor Devaney, Counselor Ianella. I know Counselor Ferrara is on his way in here. He just called me a few minutes ago and said he was pulling in. I don't know if we have Counselor Duff yet. We do not. Okay, so she's going to be joining in. I spoke with her this morning as well. I'm going to start by reading a letter from the governor. It's dated June 10th, 2020. It said, "Dear councilors, I'm pleased to nominate Edward J. McDonough Jr. to the position of Associate Justice of the Superior Court. I submit this nomination with advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I am enclosing the nominee's resume for your convenience. Sincerely, Charles D. Baker." Somehow I feel like I read this before. I don't know what it is. But we're going to start with your one witness. We're limiting the witnesses today, not our usual practice, but Judge Ford.
Counselor Kennedy, thank you very much. Good morning, counselors. My name is Daniel A. Ford. I was a Superior Court judge for 30 years, and I retired last August due to my advanced age. So I'm very pleased to be here today. I'd like to suggest most respectfully that this may be the least controversial confirmation hearing you'll ever have. And I say that because in most cases, no matter how qualified the candidate appears on paper, you really cannot know how he or she will perform as a judge until that person actually begins his or her career on the bench. And I'm sure you have sometimes been pleasantly surprised and sometimes deeply disappointed. But in the case of Judge McDonough, you do know how he will perform because he's done it. And he has compiled a solid 4-year track record for you to examine. I served with Judge McDonough on the Superior Court from 2013 to 2017. And of course, I knew him for many years before that. As an attorney, he appeared before me on numerous occasions, and I observed that he was a highly effective advocate, always well prepared and very knowledgeable in the law. In addition, he was courteous and respectful to both opposing counsel and the court, and was held in high esteem by bench and bar alike. His integrity was above reproach, and his reputation for excellence was unchallenged. But it was not until he joined me as a colleague on the court in 2013 that I came to appreciate what a truly extraordinary person he is. During our years on the court, I found him to be a prodigious worker. He was never one to bolt out the door at 4:30 and was frequently seen in the courthouse on nights and weekends. He made it a priority to get his work out promptly, and he shared my view that it is unfair to the parties and their counsel to make them wait weeks or months or longer for a decision. But he also knew that speed is no substitute for quality, and his decisions, many of which I read, were always well-reasoned, thoroughly researched, and elegantly written. On the civil side, his command of the substantive law was unparalleled. My other colleagues and I frequently went to Judge McDonough for advice on complex civil matters, and usually without even cracking a law book, he would solve our problem and give us the correct answer. He never shied away from the heavy motion practice in the Hampden Superior Court, and from his point of view, the thicker and more complicated the motion for summary judgment, the better it was for him. Now, his background as a lawyer was primarily in the civil law. And so when he first came on the court, he was somewhat apprehensive about his ability to handle difficult criminal cases. But it did not take him long to become immersed in the criminal law, and he became very confident and proficient in dealing with all sorts of criminal issues. He never ducked the tough cases, and he was equally well respected by both the defense bar and the prosecution bar. I've heard a concern expressed by some that a new judge with sparse criminal experience will tend to default to the Commonwealth's position. That was absolutely not true of Judge McDonough. He had the courage to call them as he saw them, without regard to the possibility of public criticism. I remember one case in particular when he sat on the motion to suppress, and the facts were that the police stopped a car and obtained consent from the operator to search it. They looked through the passenger compartment and found nothing, and then proceeded to open the hood and remove the top of the air filter where they found a large stash of drugs. And as they were doing that, the operator stood by and raised no objection, and in fact said nothing, arguably suggesting that his consent was still in effect. Well, Judge McDonough asked me what I thought about it, and I told him that, in my view, the motion ought to be denied. He listened respectfully and then decided to allow the motion. So the Commonwealth appealed, and a few months later, the SJC affirmed his ruling. I think that may tell you all you need to know about his legal acumen and perhaps mine as well. Although I will say it was a 4-3 vote, so I was not totally out in left field. When Judge McDonough was nominated to the appeals court in 2017, there was a regional hearing in Springfield on that nomination. And a very prominent criminal defense lawyer from Hampden County appeared to speak. She began by saying that she was there to oppose the nomination. And after a stunned silence, She went on to say, with a big smile on her face, that she opposed the nomination because he was such a good trial judge, she hated to see him leave the Superior Court. I think that sums up the way the members of the bar of Western Massachusetts feel about this gifted and extraordinary man. Everyone who appeared in Judge McDonough's courtroom, from the partner in the elite big city law firm to the unschooled pro se litigant, win or lose, left feeling that they had been treated with respect and that they had received a fair shake. Now, as Councilor Hurley made reference, some may wonder why Judge McDonough would want to leave the appeals court to return to the Superior Court. He has repeated many times, both publicly and privately, and to me privately, that he has nothing bad to say about the appeals court. He enjoyed his work there and he admires his colleagues very much. But he has come to realize that he is a trial judge at heart. He loves the give and take of the trial court. He loves the interaction with assistant clerks, court officers, probation officers, law clerks. At the end of his tenure, he served as the regional administrative justice for the 4 western counties, and his friendly and gregarious nature suited him perfectly for that position. He's a problem solver, and he greeted everyone who came to his chambers with a problem in an affable and welcoming way. He was never too busy to help someone who needed help, and he was tremendously popular with everyone who toiled in the courthouse, from his fellow judges to members of the maintenance staff. He has been happy on the appeals court, but he now recognizes that he will be even happier serving out his remaining years on the bench as a justice of the Superior Court, and I agree with him. In my view, councilors, this is a home run for the Superior Court because he will be able to hit the ground running. I can assure you that if you vote to confirm him, you will never come to regret your vote because there are simply no skeletons here. He is a very decent man, and I can say without reservation that he has been and will be again the ideal Superior Court judge. I ask you most respectfully to vote to confirm him. I thank you for your time, and I am pleased to answer any questions that you may have. Thank
Do
you.
any of the councilors have questions? Councilor Jubinville.
Always good to see you, Judge. Congratulations on your retirement.
Thank you, Councilor.
I know you've got a remarkable memory by remembering the case we had. What year was that? 81?
That was 1981, I believe. Yeah.
And do you still see Jack Flaherty at all?
I do. I just saw him a week ago.
Make sure you say hi to him.
I will do that.
He was my best roommate.
I will do that.
And I appreciate you serving on the bench. I've been before you many times. You called it the way you saw it, and you gave a good trial. You let lawyers do their thing. And it's good to see you, and I hope you many years of retirement.
Well, thank you, Counselor. It's good to see you again, too.
Councilor Ferrara?
Thank you. Judge, I want to say thank you as well. I'm sure you don't remember me, but I was a law clerk in the 90s in the Superior
I
Court.
thought I recognized you.
And
Yes,
you were
remember.
awesome.
I
You
do.
were very good to law clerks, teaching us well, and I appreciate your service to the Commonwealth. Thank you for coming up today.
Thank you, Counselor, very much. I
You're welcome.
appreciate that.
Anybody else have any questions? I have a couple of questions, if I may.
Okay.
Not directly related to the nominee, but it's a concern that I've had, that I've raised a number of times over the years. And it's the lack of diversity on the Superior Court bench. You would agree with me that there certainly is a lack of diversity on the
I
Superior
agree with you. The last African-American appointment in the 4 western counties was Judge Tina Page, who was appointed in 1999, I believe, and who retired a year and a half ago.
There was obviously a large African-American bar and Latino bar in the Springfield area.
There is.
Why do you think it is that more of them aren't applying for the bench?
That's a very good question. I've actually spoken to some. I have heard that they have not been encouraged by some members of the JNC.
Well, I can tell you this, that I have personally been reaching out to a number of African-American lawyers, as well as judges over the years, district court judges, to try to get them to apply to the Superior Court. And if they don't seem to be interested in it for some reason. Do you think it's a problem getting through they perceive that they'd have a problem getting through the JNC?
I think some do. I think some, quite frankly, are afraid of you. You know,
Well, they shouldn't be afraid of us, because I think everybody on this council would encourage diversity on the bench.
I have no
And
doubt.
I don't think that that is accurate at all, if that's the perception out there. And to the extent that you're still involved in that community, in the legal community in Western Mass, I would suggest that you encourage them to apply.
I
have.
have done that, and I will continue to do so.
I've reached out to a number of district court judges. There's a lack of diversity there as well, but I've been trying to poach some of them, some of the Latino and African-American judges from the district court to try to get them to apply to Superior Court. And they hang up on me pretty quickly when I reach out.
I've heard that the district court judges like the way they operate. They're
Right.
basically assigned to a single courtroom or a single courthouse,
Right.
maybe another courthouse. But the Superior Court, we ride circuit.
I'm
So,
aware.
you know, I'm in Pittsfield, Springfield, Boston, Cambridge, you know, that type of thing.
Okay.
And I think some of them don't want to do that.
We've all read the newspapers with what's going on in the country right now in terms of issues dealing with institutional racism, implicit bias in the court system. Do you feel that there's a certain level that still exists in the Massachusetts Superior Court of implicit bias?
I think a certain level. I think that as newer judges come on the court, I think there's less of it because I think they're more attuned to it. We had a day-long seminar, I want to say a couple of years ago, about that very subject, implicit bias, with some very gifted speakers and some written materials that were very helpful to me. I've had to examine my own conscience. I think, I was talking to somebody about this. If you have a sentencing, for example, and you have a young white man who comes in with his mother and father and aunts and uncles and sisters and brothers, and they're all dressed in nice suits and dresses and that type of thing, that kind of plays upon you. Then you have a young black kid come in, who's not all well dressed and doesn't have a big family there to support it. And you really have, I think the judge has to be aware of the possibility of implicit bias in those kinds of circumstances.
But you would agree with me that over the years, African Americans who've come before the court have been treated differently.
I would agree.
And you'd agree with me that that's simply wrong.
I would agree.
The police have been taking a beating lately, and I don't think that's completely fair. But to a certain extent, just like it is with Superior Court judges and district court judges, there's an implicit bias that exists there.
Yep.
I raised an issue the other day with Judge McDonough that happened. I have an African American law clerk. She's a Haitian immigrant. She's a law school graduate waiting to take the bar. She was stopped by a police officer. She was stopped at the corner of Ellsworth Street and Broadway in Everett, and cited for running a red light. She was questioned about the car that she was driving. She drives an older Lexus. What she was doing. This is very recently, by the way. This is not that long ago. And she was giving a motor vehicle citation for running a red light at the corner of Ellsworth Street at the corner of Ellsworth Street and Broadway and Everett. Do you know what's on the corner of Ellsworth Street and Broadway and Everett? My law office. Do you know what's not on the corner of Ellsworth Street and Broadway, Everett? A traffic zone. We appealed the ticket, and she was obviously successful since there's no light there. But it was very obvious the reason for the stop was something very different than a red light violation. And that was very recently. Do you think a lot of that goes on across the Commonwealth?
Well, I can only speculate. I mean,
Well, but it's beyond speculation for you, because
Well, you said to what, the Commonwealth.
you're sitting on a motion to suppress. Okay? And you're deciding whether the stop was good. Now, it's easy to say there was no red light there. You know, that one was no good. But say there was a light there. Now, you have to make a decision whether it was a pretextual stop of some type. And clearly, the reason for this stop had nothing to do with any red light. It had to do with, there was an African-American woman driving a Lexus in the city of Everett, which was just wrong that she was stopped. She's a delightful person. She's a very intelligent person. She's going to be a great lawyer someday. I was very offended by that, extremely offended by that. I wish I had done more about it, frankly, other than just appealing the ticket. And she described scenarios, as many of my African-American clients have, where they just get stopped for no reason. You know, Judge Desmond testified here, your former colleague,
Yes.
now on the appeals court, that was a colleague of his, how he had been stopped multiple times doing nothing, an African-American judge. And once they saw he was a judge, they just sent him on his way. It's a real problem, even in the Commonwealth of Massachusetts. Now, as a sitting judge, you had to make, you probably decided on hundreds and hundreds and hundreds of cases that are along the lines that I just described, right?
Right.
Okay. Did you ever sit there and say, this guy was stopped because he was an African-American and for no other reason?
All the time. But I think one of the problems is that, as you know, the SJC has said, if there is a legitimate basis for the stop, the fact that the officers may have some pretextual notions
I understand that.
that the stop is valid.
But if you sitting there as a Superior Court judge and you're saying the real reason they stopped this guy is because he's black, can you let that go forward in good conscience?
I had a case where the police, it was up in Franklin County, the police were, the state police were on Route 91 monitoring traffic. And Route 91 was well known as a drug highway between Springfield, Hartford, and Vermont.
I've had cases from
Right.
there.
So they see a car go by. It's an old beat up car. There are 4 black men in the car. It's late at night, middle of the night. And it's got Vermont plates on it. And the plates are covered by mud, so they can't read the plate number. They follow the car. It gets off the highway, goes into Greenfield, kind of does a circuitous route around, you know, this is in the middle of the night. It finally pulls up to a stoplight, and it pulls up beyond the white stoplight. All right, that's a violation. So the police pull them over. I guess they get consent to search the car. They find drugs. So motion to suppress. Well, again, the law from the SJC, very recent law from the SJC, is that if they have a legitimate reason to stop the car, even though they suspect that these are, you know, for drug dealers, the stop was legitimate. Now, if you and I were driving that car, they would not have pulled us over.
Exactly.
Right.
Okay. Exactly. And it's just plain wrong that they're going to pull someone over because they're African American. It's wrong. I don't care if they ran the red light or not ran the red light. If they're going to let the white guy go by that looks like me and stop the African American guy because he's African American, it's wrong. And don't you think that Superior Court judges, like Judge McDonough when he's there, especially what's going on in the world today, have to take a harder look at that?
I think I think they all do. Given the climate today, I think that's going to be essential.
I've been a criminal defense lawyer for 37 years. I've been in court. The longest I haven't been in court has been during this pandemic. Pretty much every day of my working life, I've been in court like counsel adjudant. And we've seen things like this over and over and over, where whether it's district court or Superior Court, the judges just don't get it. They don't get what's really going on here. And they just ignore the reality that there's a bias here, and they ignore the reality that the person's getting stopped simply because they're Latino or African American. And that's just wrong. I have a concern, and I'm going to vote for Judge McDonough because I know he's a great judge. I know he was a great Superior Court judge. I know he was a great appeals court judge, and I know he'll be a great Superior Court judge again. But I have a concern that everybody getting on the bench is an old white guy that looks like me. You know, we need more diversity, and it's time for us to address that.
I agree with you, Council. I hope it happens.
Thank you, Judge. Council Ionella.
Thank you. Judge, how long were you on the Superior Court for?
30 years.
What's troubling to me, you're on the Superior Court for 30 years. You say that, especially the older ones, these judges were biased, correct? That's what you said.
I said, I think that there's less of it as the newer judges come on the
So
court.
the people who've been there 20, 30 years, they were more biased than the judges who came on recently.
Well, I hate to put it that way, but I guess I do agree.
And while you were on the Superior Court, were there different Chief Justice?
Yes.
And who were they?
I started out with Bob Stedman, and then it was John Irwin, and then it was Bob Mulligan, and then it was Suzanne Del Vecchio, and then it was Barbara Rouse, and now it's Judy Fabricant.
Right. What's troubling to me, I'm getting the impression from you, and a strong impression, that the judges in the Superior Court, may be better now, but way back when, were biased against Black people. Did you ever report what you're telling us today to any of your superiors?
No.
Why not?
I was never aware of any blatant bias. We're talking about implicit bias. So if I had seen a case where somebody used a racial slur or something like that, I would have, but I never saw that.
So while you were there for 30 years, even though today you tell us that there is a bias with the judges on the Superior Court, in all of your 30 years, you never brought this up to any of the Chief Justices of the Superior Court.
I did not.
Okay. And you said that when a white defendant came in the Superior Court, if he was dressed up nice, you didn't say a suit, but if he's dressed up nice and he's with his family members, he's probably going to be treated differently than that Black person who comes in jeans or a t-shirt or whatever.
I don't think I said that. I think I said that the judge, there's a temptation on the part of the judge to treat him differently because of that. The judge has to resist that temptation. And I like to think that I was successful in resisting it, but I was aware of it.
And where do you draw this conclusion from? I mean, when I'm just curious, you're a judge for 30 years. Did you sit in other courtrooms? I'm not disagreeing with you, but like, how do you know that?
In other courtrooms?
In other words, were you an observant in front of?
Oh, no.
Like, what judges talked about it? And if so, which judges?
No,
Where did you come up with this opinion that you're coming up with today?
Because the way I recognized in myself these feelings, that it's very easy to be sympathetic to a young man who appears to have great family support, and as opposed to one who doesn't. As I said before, I was aware of that notion, and I tried very hard. I think I succeeded in not letting those feelings influence me. But the temptation was there.
And I won't get into the reason why the temptation was there, but are you telling me that you think a lot of the other judges, at least way back when, saw that temptation and didn't succeed?
I don't know that, Counselor. I really don't know that.
So
I wouldn't be surprised, but I don't know it.
Yeah. I mean, it seems like, I have my opinion. I'm not disagreeing with you, but that's the right thing to say today. But you never reported it to anyone. You can't tell me any instance of any other judge was there like, hey, I saw Judge so-and-so got reprimanded because he treated a Black person the way differently than a white defendant. I mean, I don't hear any of that from you today.
Well, I never saw it. I told you, I never saw it.
But you just thought that.
I speculated that was
You
the case.
speculated.
Yes.
And Judge McDonough's been there. When did he go on the Superior Court?
2013.
Not as long as you, but 7 years ago. Any issues with him, how he treated black people? 'Cause
Never.
I think it's a problem.
With Judge McDonough, never. I was never aware of any issue with Judge McDonough treating black people poorly, never.
And my last question is, with all due respect, you could not tell me the name of any judge today in your 30 years that you know. You might speculate, but is there any judge that you could tell us today that treated black people differently than a white defendant?
No, counsel.
Thank you.
Thank you. I just want to address a couple of points there.
Okay.
We're talking about implicit bias. I am not suggesting that any member of the Superior Court was blatantly racist. I'm not suggesting that at all. And the judges that Counselor Iannella mentioned, the former chief judges and current chief justice, I have a lot of respect for. I just want to be clear about that. But I think there's been a lot of studies that clearly show there's a lot of implicit bias in this that has to be addressed. Fair to say?
Fair to say.
Thank you.
I just want to clarify
sure.
one thing. And I agree, there is that implicit bias. But I just was wondering from you, and you've already answered it, if you knew specific judges, because if those judges were here today, well, guess what? I don't like it, and I don't know how we could remove them, but they should be removed. Because that's not right. But I understand what you're saying. You're speculating. You don't know the names of any particular judge. But I don't disagree with your premise. Thank you.
Thank you, counsel.
Anybody against something to say, Merrill? Counselor Devine.
Welcome, Judge Floyd. How nice to see you.
Thank you very much. Nice to see you.
Thank you for coming in these difficult times. It is. You know, our witnesses come to tell us about, and that's what I want to hear, what you know about this nominee. And that's it. I appreciate your philosophy and all of that, but I want to know what you know about him and your relationship with him. First of all, I do want to ask, the court has changed so much since 1981. I mean, you didn't have all of the problems with drugs and breakup of the family and all of these things. What do you think is the major issue before a judge in the Superior Court today?
Well, there are so many. The major issue, I think, as you just said, drugs is now a huge issue. I mean, so many of the criminal cases that we see, while they might not be drug offenses per se, but there is a reason why somebody breaks into a house or somebody robs a bank or somebody kills somebody. And oftentimes that reason is drugs. So I think the drug epidemic is a major reason why we have the number of cases that we do. I think, you know, in the Superior Court, we don't see a lot of domestic abuse cases. It's only when somebody is severely injured that comes to the Superior Court. But we're seeing more than we used to. And I think that is also fueled, at least in part, by drugs. But
Basically, I know you have, I like what you said and the respect you have for the nominee. And if you could give me one word, one adjective, maybe it'd be hard, you can give me more, to describe Judge McDonough.
compassionate.
That's it. And you know, I say it all the time. If someone doesn't have empathy or compassion, you don't have my vote. And, you know, I just wish that I had a magic wand and could clone Judge McDonough, because we don't have judges out there that have compassion or empathy. And it breaks my heart. So I really don't have, you know, I want to know what you know about. That's what you're here for. What do you know about Judge McDonough? And what would you, looking back, what case came before the Superior Court that comes to mind that impressed you about Judge McDonough?
When he was a lawyer and I was a judge, or when he was my colleague?
Well, just following his career. I mean, yeah, or you can go back to the 32 years that he was an attorney.
Well, that's a very good question. he didn't do a lot of criminal defense work when he was a lawyer. But on the Superior Court, when he came on the court, he, as I said before, he was nervous about being in a criminal session, nervous. And he would come to me with questions. But he adopted so quickly. I mean, I was just so impressed with the way, you know, after a month went by, you know, he would come in with a question, and it was a very sophisticated question. It was obvious to me that he had really learned his trade. I guess that motion to suppress that I talked to you about was one that sticks in my mind because I was wrong and he was right. You know, we talked about it quite a bit, and I really thought once the defendant, you know, just gave us consent and then just stood by and more or less said, "Go ahead, search," you know. But Judge McDonough was of the view that the consent should be limited to what would normally be expected. You know, can I search your car? Sure, you can search the passenger compartment, not under the hood, you know, and that's what he took. And he wrote an elegant decision. I mean, I read it after he wrote it. It was very well written, very well reasoned. And as I said, the SJC agreed with it. So that one sticks out in my mind as a time he really had the courage, you know, because it was a major seizure of drugs. You know, I'm sure the DA and the police were not happy with what he did, you know, so he ran the risk of being criticized publicly. He was being advised by a senior Superior Court judge to do the opposite, but he did it the way he saw it, and he was right. So I guess if that's answers your question, that's the case that stands out in my mind.
No, I appreciate that. I really don't have any other questions to ask. You truly know the nominee and you know the person he is, and professionally and privately. And when I vote for someone, I can't separate the public from the private. So your testimony was very meaningful for me. I listened, and I appreciate you coming. Thank you so much.
Thank you, Counselor.
Counselor Jubal?
Yeah, let me just follow up on something. Over the years, I have been in Superior Courts hundreds and hundreds of times and represented a lot of young men of color. What I found, and I still find, and I think it's very unfair.
The mic.
Thank you for
I want
interrupting
you
me.
to be heard.
What I find to be built into the system is unfairness, because most of the times when I represent a young fellow of color, 17, 18, 19, even up to the 30 years old, they usually have long records because they live in a Black community and they're treated differently by the police. They don't get the breaks that people, let's say, in Wellesley get. Police stop a kid in Wellesley. Where in Roxbury, they get no benefit of the doubt. So I remember I had a case where a young man of color was about 23 years old. He had no record. I said to the judge in the Superior Court, that is absolutely amazing, in my opinion. The kid grew up in Roxbury. He has no record. So I thought the system is unfair in the sense that judges use for punishment the prior convictions of somebody, where I suggest they shouldn't use it as much or at all, for two reasons. Number one, the minority community, not only African Americans, but Latinos, get treated much differently on the street by the police. So when they do get arrested and they come before the court, they get treated usually harsher because of the prior record. Not so the kid from Milton, where I live, or the kid from Wellesley. So to me, that's sort of a bias in and of itself that we do that. And my question to you is, and I've thought about this for a while, why do you as a judge even look at somebody's record? Why do you use that to punish somebody harsher? If an individual committed a crime, Let's say he got 3 years in jail and he did it. He's paid his debt. We all say that. Everybody says it throughout this whole system. But we don't really mean it. Because let's say 10 years after that, he committed another crime. Now he's not only punished for the crime that he's committed, but he's punished harsher because he had a prior record, even though he satisfied the punishment. So I don't know whether it'll ever happen, but I throw it out to you philosophically. Should we really use somebody's record to punish him? Because we are repunishing him to a certain extent if we do it harsher than we would somebody with no record. And should we not be aware of minority members that get arrested and hauled into superior courts? Should we not be aware of the fact that they suffer the hands of the police a lot greater than the white kids suffer?
Well, I guess I disagree with you about not looking at a criminal record. I want to know when I'm sentencing somebody what's on that record. It matters to me.
Why would it matter?
If this is a person who has a long track record of serious offenses, to me, that indicates he might not be a good candidate for probation. Or he might not be a good candidate for a short sentence with parole eligibility. If there is no record, that indicates to me that he very well might be a good candidate for probation. Now, as you know, Counselor, when the sentencing guidelines are written up by the probation department, that's one of the factors. So I think it would be unreasonable to look at the guidelines, but not look at the criminal record, because it's factored in to what the guidelines are.
Yeah, I know.
I agree with you that the judge should probably bear in mind that an African-American defendant is more likely to have a criminal record than a Caucasian defendant. I agree with that. And I would say to you that I have factored that in, but I still want to know what his prior record is.
Well, yeah, I'm just philosophically asking about that. You brought up the guidelines. I am not a favor of guidelines. I don't know why we have them. After watching what happened in our federal system with these draconian guidelines, where citizens of this country went to jail, I know of one individual who went to jail for 20 years for selling marijuana. He did he almost did like 19 and a half in a federal institution in Texas for selling of marijuana. That system in the federal court was draconian, it was unfair, it was vicious to people. And I still call the building down there by the waterfront the House of Pain, the courtroom of pain, because it is so one-sided towards the government, it's not even funny. So that's my view. But to take that approach and say, well, we should have the guidelines in Massachusetts. We don't know how the people on this committee got to decide whether somebody should get a certain sentence for a certain crime. Judge Harrington in the federal court, who I'm sure you know, he refused to sentence anybody under the guidelines. He thought they were so unfair. And then when they made it discretionary, he started taking criminal cases again. But he said, I don't have his quote with me, it's up on my desk. He said, I will sentence people the way judges sentence people since we started in this country in 1780. I will use the crime, the seriousness of the crime, the victims, whether anybody was hurt, he used the background on the defendant, and anybody speaking on behalf or whatever. But he said, that's the way we did it. We didn't need guidelines. If I walked into your court, because nobody knows how these guidelines were formulated. Nobody can tell me how everybody came up with these things. If I walked into your court on day of sentencing, and the probation department, which I don't think should have any hand in sentencing whatsoever, that's my opinion, and they said, Judge, we have these guidelines. And I said, Judge Ford, I'm glad they do because I have Jubenville's guidelines. I did them up last night. And here's mine. You would say, and Judge McDonough, everybody would say the same thing, Jubenville gone crazy. We're not going to listen to your guidelines.
That may be true.
But my point is, they're arbitrary. The people who sat on that committee, some of them have never been in a courtroom. And I have never been in a courtroom where I've walked in to a clerk's office, Superior Court clerk or District Court clerk, and I see this case sitting there. It's a big, thick case. And I go, geez, that's a 1952 case. And the clerk comes out and says, yeah, we haven't been able to sentence him. No case is sitting there because a judge couldn't sentence.
Well, can I just say, the guidelines are advisory, as you know. My own practice was I would look at them, but I would feel free to go under them or to go over them, whatever I thought was the right thing to do, based upon the things that you just said, the crime, the injury to the victim, the prior record, all that sort of thing. But I'll tell you this, I sat on the appellate division of the Superior Court for 5 years, I think, sentence appeals.
Right.
And I thought the guidelines there were useful because, I once heard somebody say, well, a carjacking may not be a big deal in Brockton, but it's a big deal in Williamstown. Somebody said that. So it was helpful to compare what different judges did in different counties by using the guidelines. And if somebody was way over the guidelines in Williamstown, for example, that was a dead giveaway. And in that respect, it helped us, I think, to, kind of even out justice across the Commonwealth in those sentence appeals.
Yeah, but I'll tell you the way they work, that in my opinion, the way they work. If the guidelines are good for the DA, they're waving them in front of the judge. And if I'm making this up now, but assuming the guidelines say 5 years, judge, guidelines, 5 years. That's where the bargaining, so to speak, starts. I come in and say, judge, it should be a year. You're looking at it and saying, well, it's 5 years in the guidelines. They want 5, Jubenville wants a year. So if you split it in half, 2.5 years, it's because they started here, I started here. And the reverse is true. If the guidelines are good for me, I'm waving them in front of a judge.
That's right.
But it's sort of where things start, like the price of a house, and you start dickering back and forth. But we're dealing with people's lives. We're sending people, as you well know, into institutions where every day is like a week, every week's like a month, and survival is every single day just trying to survive in those places. Anyway, that's my thing on that, but thank you for listening.
Thank you, Counsel.
Excuse me, could I just say, interrupt? Could we have the judge take off his mask? He's at least 15, 20 feet from us.
That's up to you, Judge, whatever you want to do.
I'm getting eagle eye over here.
We're going to be done with Judge Ford in 30 seconds, so I know he wants to get out of here.
I'm
I didn't really
saying,
think it was
Counselor
you.
Kennedy.
Huh?
Kennedy. Counselor Kennedy.
Yes. Mary?
Yes. I
How
would
are you,
like-
Councilor Hurley? Would you like to be heard?
Yes, sir.
We can't see you at the moment, but please go ahead.
Believe me, you're very well served by not seeing me. In any event, I would just like to, as the counselor from the district that we've been discussing, in terms of trying to recruit minorities and women, it has been my goal since the day I took over as the governor's counselor from the Western Mass region to try as hard as I could to recruit young Blacks and Latinos and women to the bench. And there have been resistance or other issues that I won't go into But I think that I finally reached a point where you're going to see some nominations coming out of the Western Mass that include Blacks and Latinos. That's all I'm going to say, but that was basically a goal of mine from day one. And there has been a reticence on the part of not only Blacks and Latinos, but some other members of the legal community to come in front of our body. So I just want to make that clear.
Thank you, Counselor Hurley. Counselor Duff, did you want to be heard? Okay, we can't hear. Counselor Duff,
That was her.
did you want to be heard?
I can't unmute, but that's okay.
She's good, Terry.
Okay, thank you, Counselor Duff.
Okay, I'm sorry. I was having trouble getting unmuted. No, I think this has been a good and robust discussion that we will be continuing with all the appointees going forward. But thank you for your time as a witness to answer some of these.
Thank you, Counselor Duff.
Thank you.
I don't have any further questions. I'm sorry we had to make you the sacrificial lamb today, bringing these issues up. But it was great to see you, Judge, and we really do wish you the best in your retirement.
Thank you.
And we appreciate your testimony about the nominee. Really means a lot.
Thank
And we
you.
appreciate it.
And
Thank
you
you.
are not the nominee.
Where else? You can step down if you like now, Judge. Thank you.
All right.
I don't believe there's any other witnesses because in favor. And,
That's correct.
I'll just ask for the record if there's any witness opposed. Hearing none, I would turn it over to you, Judge McDonough.
Thank you, counselors, Chairman Kennedy, those who are here and those who are joining us by Zoom, Counselor Hurley and Counselor Duff. Let me begin to express my gratitude to Counselor Hurley. She has been incredibly supportive and encouraging to me. And when I did share with her my, I don't know what to call it. It was a goal. It was my feeling that I might be better, serve better on the Superior Court. I was staring at her face at the time and I did not know what her reaction would be. And when she smiled, it meant the world to me because I really had she was instrumental in me going on the appeals court. And I was very grateful for that. But Counselor Hurley, I will never forget that moment and your encouragement and your support. I want to reintroduce the family members who are here. Our youngest child, Bobby, is 14 years old, entering high school, and I'm happy he's able to be. He's the only one left at home. Were it not for the COVID days that we're going through, Bobby's one of 6. He has 3 brothers who would be here. My oldest son, Eddie, my son, Michael, is in practice now. My son, Sean, in Seattle, would be here. And of course, our 2 daughters, Maureen and Kate. I just want to say a word about my daughter, Kate. She just became a nurse in New York City. And her first assignment was the COVID ICU ward in New York City's largest hospital, Cornell Presbyterian. So we're obviously sweating bullets for our Kate, but she's so funny. She said, "Dad, we are trained. We know how not to get the virus. Stop worrying." And she can say that all she wants, but we are worrying. And I appreciate everybody's concern for her. I'm sure she's going to be fine. I do want to, and thank you, Counselor Hurley, for introducing my wife and my son. I do want to say a few words about my wife, Melissa. She's wonderful, devoted, and loyal. She would have to be, I guess, to put up with me. She has many titles. She is wife, mother, Mass Mutual corporate compliance executive. But as far as I'm concerned, her most important title is Chief Executive Officer of my life. And that's exactly how I want it. And I hope she has that title for all my days. Each time I've been nominated to judicial office and come before this council, Melissa has been by my side, and that number is 3. This is the 3rd time. I can say confidently that if it were not for her love, support, and loyalty, that number would not be 3. It would be 0. There's no way I would be a judge if it wasn't for my wife, Melissa, and I will always be grateful. I want to especially thank Superior Court Judge Dan Ford for being here for me today and for you, and I was delighted to see you question him. Dan's words were so kind, and I will always appreciate them. As you know, he served on the Superior Court for 30 years, beginning in '89. All Dan Ford did, except for the few years he was the first assistant DA out in the Berkshires and his years in private practice, all he has done is given his entire professional life in the service of the Commonwealth. If there's a harder working, smarter, wiser Superior Court judge than Dan Ford, I have never heard your name. Obviously, I want to thank Governor Baker and Lieutenant Governor Polito. I also want to thank Lauren Green Petrino, the Executive Director of the JNC, and her deputy, Emily Gauthier and Katie Babin, for the help and support and the confidence they have all shown in me by nominating me to again serve as a Justice of the Superior Court. I also want to thank my current Chief Justice of the Appeals Court, the Honorable Mark Green, for all he has done for that court and all he has done for me. 3 quick points on Chief Justice Green. He knows that court, he loves the appeals court, and he loves and cares deeply for all 24 of his other appeals court justices. While he began as my colleague and then my chief, he soon became my friend. And I thank Chief Justice Mark Green for what he has done to me. I just want to answer the question, why I applied to move back to the Superior Court after serving as a Justice of the Appeals Court. I can see this is a rather unorthodox move. When I was interviewed by the JNC way back in March, it seemed like 100 years ago, just before I had to certify I didn't have any symptoms, that we all saw this horrible thing coming then. One of the members of the JNC, in a rather incredulous tone, said this to me: "Why are you doing this?" And then before I could answer, he said, "Has anyone ever done this before?" And I said, "Gee, I hope so, because I'm really not looking to make history here." And I wasn't, and I still am not. I can say, though, that the appeals court will soon celebrate its 50th birthday. And in that near half century, no appeals court judge apparently has applied to the governor to leave the appeals court to serve in the trial court. As a bit of a footnote, I want to pay my respects to the late Justice Edmund Kevel, who was one of the original 6 appeals court justices. It turns out 4 months short of his retirement, he stepped down. He wanted to go back to the probate court. And I didn't know that he did that, but he did that on recall. So he didn't have to apply and submit himself for consideration to the JNC or anything like that. And he did not have to be nominated by the governor even or confirmed by this council. But that's the only time anything close to this. And so I acknowledge this is an unorthodox move. So here's my answer as to why I'm doing this. And it has its roots in one of my favorite old sayings called Occam's razor. You may know that this saying was attributed to an English philosopher, William of Occam, and it's known as Occam's razor. And the razor means cut to the chase, cut to the chase. And this is cutting to, he said, quote, "All things being equal, the simplest answer to any question is almost always the correct answer. So keep it simple." And here's my simple answer. I have been honored to be appointed, confirmed, and to have served in 2 of the finest courts, not only in Massachusetts, but in the United States, in my view, and even in the entire world. We know that the Superior Court is known as the great and historic Massachusetts Superior Court, the oldest common law trial court in the Western Hemisphere. And the Mass Appeals Court, I didn't quite realize what I was getting into, and I loved every minute of it. But the Mass Appeals Court, as the lawyers will know, and the council knows, has to hear all appeals from all 7 trial courts. The SJC has to take first-degree murder appeals, but they don't have to take anything else. And that's what the appeals court is for, to handle everything else. The appeals court has to and does take appeals from the Superior Court, the District Court, the Boston Municipal Court, the Probate and Family Court, the Juvenile Court, the Land Court, and the Housing Court. And it's quite overwhelming. That's a lot of law from a lot of courts, and for me to learn in 3 years. And the president emeritus of MIT, one Jerome Wisner, had a saying. He said, "Getting an education," it's a quote, "getting an education from MIT is like taking a drink from a fire hose." Now, I didn't go to MIT. I'm proud to say I went to the University of Massachusetts at Amherst. But I can say after 3 years on the appeals court, hearing all those appeals from all those courts, that's saying sipping water from a fire hose. That's an apt analogy, I think, to being an appeals court judge. I have loved every minute of it. I have no regrets moving in 2017 from the Superior Court to the Appeals Court. Far from it. It has been the honor and learning experience of a lifetime. But having served in both courts, I hope with dignity and honor, I have come to the honest and sincere view that I can best serve the Commonwealth back in the courtroom, back in the trial courtroom on a daily basis. I wish I had invented this, but someone else said this to me, and I think it is so true. A trial judge every single day while in a courtroom has the opportunity to do at least one, and usually several, but at least one act of justice every single day. That is my pledge, should I be confirmed. Finally, I want to say in preparing these remarks, I was hoping to come up with something profound about what it really means to be a trial judge. Luckily for me, I did not have to compose anything because I found some wonderful words written by another trial judge, and she couldn't be here today, but who is known to all of you. And I could not top what this judge said about being a trial judge. Quote, "Our colleagues, our fellow judges, cherish the opportunity to serve. We recognize both the honor and the obligation entrusted to us, and we accept it with humility, dedication, and with joy. We know we do not always achieve the ideals of service for which we strive, but we do strive, sincerely and honestly, and we find satisfaction in that effort, as well as in our daily interaction with the enormous variety of people and problems who come before us." Now, end quote. Those wise and gentle words were spoken by my former, and this council willing, my future Chief Justice of the Superior Court, Judith Fabricant. And she said those before she became Chief Justice. She was writing about the Superior Court judges then celebrating the 105th anniversary of that great court. I will say those words describe perfectly how I feel today. And I suspect how every single trial judge in this Commonwealth feels about what they do every day. And Chief Justice Fabricant, I thank you for those words of inspiration. Thank you, Chief, and this council willing for welcoming me back to the Superior Court with open arms. I would not have done it otherwise. And I welcome all your questions.
Sure. I promised Council Iannone I'd call him first. Council Iannone.
Thank you. Good to see you, Judge.
Good to see you, Counselor.
I can tell you this, everyone I spoke with about your nomination, everyone gives you high marks. You're a great addition to the Superior Court back then, the Appeals Court. I don't know anyone who's had a bad word about Judge McDonough. But let me just, a couple of questions. You heard Judge Ford. He talked about that he speculated that there was some type of bias with judges on the Superior Court. You were on that same Superior Court. Your opinion?
Well, I think I can add something to that because I had the honor of serving on a newly formed committee on the Superior Court called the Implicit Bias Committee. And there were a number of us there that we met on a regular basis. It included Justice Desmond, Justice Peter Krupp was on that committee. I was on that committee. And one of my dear friends and colleagues, Justice Ken Desmond, was on that committee. And we would sit and we would share our concerns. And I shared my concern about bail. Because, you know, when you review a bail that it comes to you from the district court, you're supposed to take in a lot of factors, including ties to the community, home ties, stability, things like that. And I had a concern. I said, look, if the incidence of single parenthood is higher in the Latino community and in the African-American community than it is in the white community, then you could have someone before you, mom isn't there because mom's working, okay? The single parent is working. No one is there. Yet if someone has the strong nuclear family that many of us are blessed with, mom's in the courtroom, dad's in the courtroom, Nana's in the courtroom, maybe his boss is in the courtroom. And it just, well, who's got the stronger ties to the community? Well, for all I know, they both have strong ties to the community. But it's just very, very, there's a risk there that you're going to slide the wrong way and support someone who has mom and dad as opposed to mom who's working. And I had a concern about that, and it hit me. And unlike Judge Ford, I did get feedback from other judges. Yes. And Judge Krupp used to keep a list just to make sure he didn't slide that way. And so I think I share the concern. We all had a concern, and we had to be conscious of it. There was a video that we were able to watch from all over the country, and one I'll never forget, an African-American judge in Minnesota said he found he was being too biased against African-Americans because he said, I realized I was being tougher on my own than I was others. And he said, that was wrong. Can you imagine that? And it was a real shock to see a judge acknowledge that this is a bias that was creeping around and he didn't even know it until he examined his conscience. So I think it is out there. And I think Judge Ford is right on sentencing, the same thing. If there's a big entourage out there, people who are of means, who can take time off from work and show up and put on a show like that, there's a real risk that that creeps in. I think, how do you deal with it? I think you deal with it by being conscious of it. Being conscious of it. If you're not conscious of it and always re-examining, then it can creep in. And that's why they call it, of course, implicit bias. So we're all human and we're all have frailties. And I think that committee certainly was a big help to me. And I trust it's still thriving. We can't be, and it's like asking jurors. If you don't ask them about their biases, you're never going to learn. And if they have them, we need them to tell us that they have them. And then the question is, can you set them aside and swear to judge the evidence fairly and impartially? And if there's the slightest concern that they can't, you just cannot let them serve because it creeps in. So I wanted to just kind of respond to the questions that Judge Ford was facing because he didn't have, that committee is a fairly new committee. I think it was formed in 2014 or 15, and it's long overdue. I also have a theory on why it's so difficult to recruit African Americans to the bench, but I won't go there tonight. If you want to hear me on that, I'll give it.
Talk to afterwards.
Okay.
This implicit bias committee, it's still in existence now,
I'm quite sure.
and you're a judge in the court system.
Yep.
Tell me some of the changes, recommendations that especially when you were on there, that the implicit bias committee suggested, recommended, that would affect, in this case, we're talking about Black people.
Well, since I left in 2017, I guess I can only share with you reassurance that there is an awareness of this. And that's the first step.
But just
I couldn't tell you.
When you say there's awareness, is there a
Statistically,
directive like in 2017, like from the Chief Justice or the Chief Justice of the Supreme Judicial Court? Hey, judges, there's an implicit bias against Black people. When you're dealing with bail, remember this. When we talk about one of the criteria being roots in the community, I want all you judges to realize that some of these Black defendants don't have as many roots because of single paradigm, just what you said.
Yeah.
Was there this actual directive? If I was a judge in the Superior Court, was there a directive? Was there some type of, memo? I mean, it sounds good, but that's what I'm trying to get at.
well, I can assure you that the committees, all the Superior Court committees report to the full court at all our conferences and share the results of their committee meetings, usually in written report. And I can tell you that the results of our committee were shared with all 82 Superior Court judges. And I think it's an eye opener.
No, that's good. So if I talk to the next person who comes before us, or someone going to be elevated, or someone speaks for someone who's on the Superior Court, and I ask them about the results of the implicit bias committee, again, maybe not back to 2017, will they be able, do you think they'll be talking about, yeah, especially with respect to bail? That was one issue. Was that written part of the memo when I asked people about bail, how Black people should be treated more fairly with respect to bail?
I'm sure you'll get that response, that this has been reported. The Chief Justice Fabricant was I'm sure she attended one or two of our meetings at least, and I'm sure that you'll get a positive response about that.
And do you think if I write a letter, you may not know, to the chief, and I say, can I have a copy of that memo? I assume it's a public memo. Why are you laughing?
I don't know the answer.
I mean, if it was given to all the judges, is there any reason that you can think of why it should be private?
I can't think of any.
And do you recommend that it should be public?
I can't think of any reason not to.
One other thing, because I think there is a bias too. But I think there's also another bias, as no one's talked about, is on the parole board. I'm only one of 3 members of this parole board. I think it was two appointees before this that had a law enforcement background. And I made a statement that day that I'd never vote for another member of the parole board, a new appointment, if they had a law enforcement background. We need people with social science backgrounds. We need defense attorneys. With all due respect to my esteemed colleagues here, this is a nice conversation. Words are good, but I hope action will follow from here. Because I agree, there is a bias. We have too many white people on that Superior Court. Again, I'm voting for you. I gave you high remarks, but I hope this body stands tall next week, the week after that. With respect to the parole board, like I said, I was only one of 3 members, and there are a lot of people. I think it was this room. There must have been 100 people who spoke against that nominee, and I was only one of 3 people who said, I hear your pain, I feel your pain. And I voted against that nominee. Unfortunately, that nominee went through. My last question. We've talked a lot about how people bias, how people are affected today. What will be the biggest change for you? You were on the Superior Court, I think, 2013?
Almost 5 years.
Excuse me?
Almost 5 years.
Okay. How will you treat Black defendants who come before you today, some 5 years, 7 years later than you did in 2013? Because everyone's talking about there's a bias. You read in the paper, I hear you folks today. How will you treat a Black defendant differently than you did in 2013?
I think I can, I know that serving on that committee was a wake-up call. And it is impossible for me to view a Latino or Black defendant without the implicit bias warning screaming in both of my ears. It's just impossible. If you go through that self-examination and you hear others, that's the key, reinforce what your concerns are, it's indelible.
I'm not going to ask you for any specific case, but looking back in your career, do you see today and say, you know what, maybe in 2014, that bail that I set for so-and-so, if that was today, maybe I'd be a little less stringent on the bail.
Yes, and I can give you, if I may,
appreciate that.
I do have a specific case that that comes to mind. It was a Chicopee case. Police, there was a robbery, a nearby robbery, and the dispatch just identified a young Black male. That was it. And the officers were in the neighborhood, but it was not like right next door. They're in the general area. And they came upon a young Black kid, and that was it. He was Black. That's the only thing that matched the description. And they decided to stop him. And before they did, he kind of walked quickly to get away. And as we know, that could be flight, consciousness of guilt. It's one factor that can be considered. And they pulled him over, and you know, they had a cop can ask you a question. But to conduct a threshold inquiry, you need more. You need reasonable suspicion that something's going on, or you need certainly fear of safety to do a pat down. And these officers did more than ask questions. They stopped him. They patted him down. And the only reason was he was a Black kid. And this came before me on a motion to suppress. And they found some drugs in his pocket. I don't recall exactly what, but it was just possession. And he was arrested. And it came before him in a motion to suppress. And the only issue was the flight. Well, he tried to get away. And we suppose that provides some reasonable suspicion, supposedly. And I should have allowed that motion to suppress, and I didn't. Now, shortly thereafter, the SJC came out with a case, the Warren case. It was written by Justice Geraldine Hines. And she said that flight shouldn't be enough because, and she cited some very impressive statistics from the Boston Police Department about how some people flee because they're afraid of the police. And guess what? That's African Americans. And so I think of that kid, he didn't run. He just kind of wanted to get the heck out of there. And I should not have credited that factor. And under the Warren case, it's now the law that you shouldn't automatically credit flight, because it just may be that an African-American kid is getting away because he's afraid for his own safety. So I regret that I didn't, I left out a very important factor. As they're frisking the kid, they get a dispatch, hey, we got the robber. So that he wasn't the robber. But by then they're on to something else, what's in his pockets and things like that. So I think that ruling was wrong on my part. And I'm enlightened now by the Warren decision.
Well, I appreciate that.
Yeah.
It's,
Can I just say one other thing with Judge Ford? He's right. Even if it's you suspect that there's a bias in the arrest, as we've heard this morning, if there's a legitimate reason, you're supposed to credit that. In other words, what's in the mind of the cop is that he's absolutely right on the law. But I think we can allow those motions, because how else is the SJC going to get a chance to re-examine that law unless we give them another opportunity? So my inclination is, if I think that the officers, based on the facts before me, arrested somebody because they were black, and even if there was a legitimate reason, I'd be inclined to allow the motion to suppress, because that would give the law can only evolve if we give the SJC more opportunities to do that. If I think to a moral certainty that someone is arrested because of their race, I can't see myself denying that motion. Now, I have to be convinced by the evidence, obviously, because I think that should always be subject to re-examination by the court that I sit on now, the appeals court, and also by the SJC.
I appreciate your testimony. You are very compelling. I really appreciate it, and I'd be more than happy to vote for you when your name comes before the council.
Thank you,
very
Councilor.
much.
Councilor Devaney.
Thank you. Pleasure to see you again,
Yes,
Judge.
Councilor, you too.
First of all, I was going to talk about bail, and my colleague did a good job about making the point. And also, I also was concerned about, I suppose I'm thinking of, you spent 3 years on the appeals court and 4 years in the Superior. What will you bring from your 3 years on the appeals court to apply it in the Superior Court?
Well, I guess I would encourage and I will encourage my new Superior Court colleagues, if I'm confirmed, to don't be afraid to rule more quickly. The appeals court doesn't need, 17 pages. People need to get their decisions quickly, and don't be afraid to if you know your decision, to do something more brief. The important thing, as Judge Ford said, get the decision out to the lawyers and to the people. Can't wait that long. I hated being behind. I used to, one of my colleagues used to get more behind than I did, and I would say, you know what I do? I'm not trying to be a hero. I come in on a Saturday because the reason I'm behind is my fault. Don't let yourself fall behind. Don't worry about making something so pretty and beautiful so that the appeals court can see how wonderful I am. Get the decision out, get it out succinctly and clearly, and I think I will do that. The other thing I would stress is that for the most part, we are in awe of the trial judges. They do an enormous great job. And I would reassure them, don't worry about getting reversed. Make your decision and let the chips fall where they may. And when I was a trial judge and I had a tough call, like that case Judge Fordman, I said, hey, listen, if I'm wrong, I want to be reversed. I don't want to be wrong. I don't want to hurt anybody. Don't be afraid to get it done. If you're wrong, you've got two safety nets. You got the appeals court's your safety net, and you got the SJC. Who else goes around having two safety nets to catch their mistakes? I always felt it was very reassuring to know that if I made a mistake, there were two courts and their only job was to catch my mistakes. I found that very reassuring and gave me more courage, quite frankly. So that's what I would share that with my new colleagues.
There's been a lot of conversation here today at this hearing about minorities because it is front page. And I'm not going to talk about me, but I do have a concern. We had a parole board with a wonderful nominee who had been appointed by 2 previous governors. She's Hispanic, she speaks Spanish. In addition to be outstanding, she was a valuable member being able to speak Spanish. And I did not vote to have her removed to vote for the replacement. So I stand by my, convictions. So I'm not going to go into my record. But I do want to say, and I did say it to Judge Ford, I do wish I had a magic wand and to have more judges like you with integrity, honesty, in the ability as a judge to do the right thing. And today, you coming before us, it's just true to form of Judge McDonough. You did it open, public process. And I want to tell you, I appreciate that. And I want the public to know what that means, okay? First of all, this is very unusual to have a judge come and ask to be returned to a lower court. I'm not a bit surprised because I know you, I voted for you twice, I've met with you for hours, and I know you love the Superior Court, you love the interaction with the people, and I think you really missed it. And if I'm wrong saying that, you can correct me. So having said that, this is not the usual. So I want the public to know that when another judge wanted to be returned to a lower court that he originally had been voted by the council, did not do the public process. He went to the court. It's permissible by statute, but not a public process for us. And he asked to go back to the district court. Superior Court was too busy. He was stressed, too much work, and that was it. I heard from an outsider that he had gone to the district court. This council never got a word that he was on the district court. Our records in our council office show that he retired from the Superior Court. And that was it. So it is, to me, it was very disrespectful. It wasn't, wasn't the way that it should be because, and then when he did retire from the district court, we weren't even told about that. So for our records, as a governmental body of the Governor's Council, he retired from the Superior Court. And I thank you. You did it the proper way. You asked the administration if you could go to the district court. You went before the Judicial Nominating Commission, who is the recommending body. And then the governor sent us a letter recommending you. And here we have the hearing for the public process that is in the newspaper, it's in our website, and you're here. So I want the public to know this is integrity, and this is the kind of judges we should have. So I'll get off that point. But anyway, I just want to remind people who don't know that when you first came before us in 2013, there were so many people that sang your praises, attorneys, and your partners, and I'll never forget it, they said that you have the highest ethical standards and the highest personal integrity, and you have never let me down. Now, I want to mention this for the public to know, that not only are you have compassion and you know the rule of law, but you know how to solve problems. And in the 90s, there was a problem when the sheriff, Ash, was told that he was not in compliance, that you only could fit 225 prisoners in the jail, and there were 800. So it was a federal court order, and you stepped in and told Sheriff Ash that he could take over the armory, and there was a lot of, you really caused a lot of, a lot of commotion over that, but it was done. And it worked out very well, and they were in the National Guard Armory for over 2 years when they built a new jail. I mean, that's problem solving, and it's not, and I've always said about myself too, it's not always popular to do the right thing, and you do. And so I want to say that because that was an amazing thing to do. I don't know what he would have said. And he even said publicly, Sheriff Ash, that it was is a monumental thing that you did. It was so amazing. So I think that we have to, to thank you for that. Now, I want to ask you questions now pertaining to the Superior Court. You're going back. Okay. Now, we talk about the increase in drug addiction. And I have said it, and people are tired of me saying it. We need more drug treatment centers. We only got a few, only have one for women. Now, when you go back to the Superior Court and you have someone that's drug addicted, what can you do? How can you change it?
Well, the first thing is I don't hit the ground running. I take issue with that. There's a lot for me to get caught up on. As you point out, the Superior Court has to implement our court's decisions, and they have things like, as you well know, standing orders, best practices. And I haven't seen a Superior Court new best practice since 2017, so I'm behind on that. And I've talked to Chief Justice Fabricant about it. She was very complimentary about saying, well, don't have to give you the normal training. I said, that's true, Chief, but I need some catch-up time as to what you've been doing cutting edge that I have not experienced. And I was always interested in the community correction centers, which is there's one in Springfield, and it's run by the probation department, and it's intensive probation every day of the week. And the community corrections, I think, is something that's not on everybody's radar. But as opposed to, it's like ultra intensive probation. They're on them every day with the electronic monitoring and reporting in person and so it's I think a wonderful alternative to incarceration. And it's so tough. Some people say it's too tough because you don't always be violating people's probation, because that could get somebody back in jail. But I was always interested in the community corrections, and I thought it was underutilized in the Superior Court. It's utilized more in the District Court, but I was a big fan of it. And I would continue to explore whether that remains a viable. I don't know. It's been 3 years, and my information is stale in that regard. So I had a reputation as being a light sentencer, and I think the reason I did was because I had the honor of representing Sheriff Ash for 32 years, and he was all about reentry. For example, there's fair. There's 1 year in prison could be fair, and 3 years in prison could be fair. They're all within the range of fair. My tendency was to go lighter because it's one thing to be away from your family, your friends, and your work, and your elements for 1 year. But if you go 2 years without being with your friends, 3 years without being with your family, 4 years, it makes it that much harder to re-enter society. So my instinct, and because of my experience with corrections, was the whole point when someone goes to jail is that they come out a better person than when they went in. And sometimes you make it so long that it just looks impossible. Sheriff Ash's recidivism rate was an astonishingly low 17%. Now, keep in mind, that's a county prison. That's not Walpole. And that's of people who complete the programming, okay? And so my goal is that the sentence should be to meet the crime, but not a day longer, because it makes it that much harder to get back to your life.
Now, you wrote, I liked what you wrote about discretion, and, what your opinion was about discretion in sentencing. So you could talk about that. And also, I know that you can't solve all the problems, but what do we do about alcoholics? What do we do with people with mental issues that come before you? So if you want to address that, your opinion, your discretion.
Well, my own culture has its issues in terms of cultural issues. And I lost a brother to alcohol at age 36. I lost a nephew to alcohol at age 36. And I said to my sister as she was struggling with her son, I can't believe I said this, but I said, he needs to commit a crime. He needs to commit a crime, because if he commits a crime, it was Sheriff Ash at the time, now Sheriff Cochee, he will get sent to a special facility to deal with addiction, because he'd been in and out of rehab his whole life and he failed every time. And I can't believe I was saying this. He needs to commit a crime. And he didn't commit a crime, and he died. He drank himself to death. That doesn't happen. He used to call it the Howard Street facility. Now it's moved over to Mill Street. And you get people at that point. I mean, I would have a bail review, and I was afraid this kid was going to overdose on fentanyl if I let him out that day. So I would say, look, I'm gonna deny the bail reduction, but come back in 30 days, come back in 2 weeks, see how he's doing. We can revisit a bail. I can revisit my bail review decision. But right now, it was clear the guy, he hadn't made any progress. And I said, he's going to overdose if I let him go today. And so I would do that. I would say, come back, and see how you're doing. See how you're doing. And we can talk about that facility. Because if you walk right into a treatment facility 2 days after he's arrested, he can walk right out. Right? He's not, unless he's committed civilly under Section 35. So on the one hand, you don't want to over-incarcerate, but you want him in a place where they can grab him by the ears and keep him for a while and save his life. And so sometimes that means incarceration until he's clean, and then we'll look at it again after that, you know? So I think you got to get a little creative, because it's not a cookie cutter. They're not all the same. They're not all the same.
When you have a 209A before you,
Yeah.
how can you determine if the accusation is truthful?
Well, we don't get a lot of those in the Superior Court.
But that's, yeah.
But I can share with you this. When the district court judge would go on their 3-day conference as the Raj, Regional Administrative Justice, I would have to find someone to cover. And one time I couldn't find anybody. I said, well, I'm going to do it, you know? And I came out of that thinking, you know, the district court judges should get double. The stuff they deal with on a rat-a-tat-a-tat-a-tat base, the 209s just keep coming. And of course, on the judicial response, you get the calls in the middle of the night. I didn't get those. I wasn't on the judicial response in the appeals court. And I kind of didn't mind them because, you know, listen to an officer deal with someone who's been beaten. It's extraordinarily tough situation. And you just simply have to look and listen and decide, who do I believe? Who's more credible? If you're doing a 209, and I did a lot of them in the district court when I was, you know, covering for them in their conferences. And it's a staggeringly difficult job. Staggering. It's just, thank God, because you just see how many lives have been saved. You know, at least it's a timeout. You know, when you get the call at 3 a.m, at least it's you know what? Let's preserve the status quo. Let's keep people safe till 9 o'clock tomorrow morning or 2 o'clock, and they can revisit it. Frankly, I never heard a judicial response call that I didn't find was credible. Not one. And it's a temporary interruption of liberty until the next day at 9 o'clock. And I think better safe than sorry. But I never heard somebody that I thought was faking at 3 a.m, crying to an officer that I'd been threatened or I'd been beat. I never heard that. I found them to be credible at that hour of the night, and I wasn't going to take a chance on somebody getting killed.
You know, it's so outrageous. It's so egregious to me. And we're seeing in the past years the increase of children being killed by their own parents. And it always struck me that why is it that a child can be killed and yet the person who has done it doesn't get a sentence if that was a grown person? Why is there a distinction between a baby and a grown person? I can't understand that logic, that law at all, you know. But you know, we see all of this. I mean, we just saw 2 children. They just found their bodies in the backyard. And I mean, these are families. These are families. So I don't know. Our whole society is upside down. I don't know, but you know, the court has changed a lot since 1981 when Judge Ford was there. I mean, you didn't have to talk about eggs and saving them or destroying them or whatever. I mean, there's, you know, where is the law to, you know, is it just as you go along, you have to make up your own mind in these kind of decisions? Or if a gay couple who gets a child, I mean, all of that, it's a whole different thing. I'm sure that the judge didn't have those kind of things in 1981, right? So.
I went on the court in 80. I had a case with prosecutor.
Okay,
So, yeah, 89, I
yeah,
think.
but it was not the norm. Yeah,
That's correct.
yeah, it wasn't the norm. So, okay, so what do you think is the greatest challenge for you to go back to the Superior Court?
I want to get back up to speed real quick because I've missed the best practices that have come out. I've missed some of the standing orders. I've missed getting input from my other 81 colleagues. There is a bit of truth to the ivory tower concept. You're kind of insulated up there. And so I want to get back up to speed. That's my biggest challenge. What have I missed, you know?
I do want to say that Judge Green, everyone is really, you know, sorry to see you go, but they're happy. They know you're going home, you know? So I think that that's a given. But I guess that, you know, one of the things what impressed me was about how sincere you were and compassionate and all of that. But the other thing is I look for life experience. And I really like to see your age come into court because you came with 32 years. Wasn't it 32 years you
Yes.
came before us the first time? And I think you can't compare that to someone that hasn't had the life experience. And I don't know if you've had another grandchild since you came before us, have you?
I have 4 grandsons.
Yeah.
People
But
ask me
you
their
know,
ages and I say, well, they keep changing, so I keep forgetting a little bit.
But I can't tell you how pleased I am. This is such a pleasure. And I think I can speak for everyone here that, you know, really pleased. But you did it the right way. And I'm so proud of that, to be able to vote for you to go back to, you know, Superior Court, which I didn't in the past, and it was wrong. And I have to say it, this is the way to do it. So I thank you so much. And I'll be very proud to vote for your appointment back to the Superior Court.
Thank you, Counsel.
Thank you.
Council Ferrara.
Thank
Kennedy,
you. Judge, thank you very much for your service to the Commonwealth. We had a great conversation again a couple of days ago, as we did when you were nominated to the appeals court. Your reputation is nothing but stellar. I know a great friend of mine who I've worked for 28 years, who's an exceptional trial attorney, Jay Lynch, thinks the world of you, that you're kind, which is very important to all litigants at all times, and you're wicked smart as well, as we would say in Southeastern Mass. So you certainly have my support next week, as I told you on the phone, and I really enjoy the fact that you're so bragging about your family, and you love your family like I love my family. And I also have a daughter in New York named Kate, who works at Mount Sinai in public health, and she's happy that she has the antibody. So she had it and was sick for a little bit, but they're smart kids. They're smarter than you and I probably are, Kate's. So congratulations on a great career. And I'm glad you're going to be back in the trenches in the Superior Court. Thank you for your service.
Council Hurley.
yes, I just, I don't have any questions. I know this guy inside and out, and I'm proud to vote for him. I do have to leave the meeting at this time because I have a doctor's appointment that I don't want to miss. So I'll see all you folks next week. And I would be very surprised if there is a negative vote on your nomination, Justice McDonough. I'm very proud of you. Thank you. Bye.
Phil Mary.
Thank you.
Thank you.
Thank you, Mary.
Council Duff.
I'm trying to,
Council Duff.
hello?
Hello. Hello.
We called on you. You there?
Can you unmute me? Did you
Yes,
unmute me?
yes.
Yes.
All right, great, thank you. I had a great long conversation with you, Judge. It was a pleasure to speak with you, and thank you for so much time. Particularly in light of the conversation today over some of the inequities in the justice system, not just on the bench, but just in general. Something I would ask of you that I've actually done with some judges is go into some of the public high schools and talk. If you can team up with a person of color who's also on the bench or serves in some capacity, I think it could be helpful. I've had remarkable conversations with some of the justices with high school students, and it's really it's a really great opportunity for us. And for those of us who are frankly, as I've said many times, just because of the color of my skin, I am highly privileged. I'm a well-educated, very privileged person and an elected official. And I truly believe because of that, I'm held to a higher standard, and I should be. And I feel the same way about folks who go to the bench. So that is my ask of you. I think that you're certainly on the right path and that you're going to do well. And I hope you make the next 5 years really count. Thank you.
Thank you, Councilor
Counselor.
Duff. Councilor Jubenville.
Thank you, Chairman. Oh, I got to get this thing off here. I just wanted to point out, Judge Ford listed the chief judges of the court at his tenure. I believe was Barbara Dorchel-Cara was one of them. Oh, okay, that's right. Yeah, I'm sorry. Yeah. Who was a lady of color? I was trying to figure out judges that have been at the governor's council 3 times or more. I'm sure there have been in the history of the council.
Justice Lowy, District Court Superior and SJC.
Yeah, but I'm thinking also of a judge who was a district superior appeals and SJC.
John Graney,
Was he?
actually Housing Court, Superior Court, Appeals Court, and SJC from
And
Western Mass.
Joe Nolan also was.
I'll miss no opportunity to brag about Western Mass. Fran Spina,
Oh, yeah.
Justice Spina. Thank you, Dan. Thank you. Yes.
So it was great listening to the questions and the answers here today. I'm very fortunate and I'm very honored to have been before you in the Superior Court. And somebody brought up bail, and the case I had before you was a bail issue
I remember.
where a minority, Asian minority member, woman was before you. The district attorney's office wanted $1 million.
I think it had been set by the district court at $1 million.
It was set at the district court. I
Yeah.
went 4 times to Westfield to try to get a bail reduction, denied every time. And the DA happened to be a second tier relative of mine
Yeah.
from Holyoke. In any event, you showed your common sense, I believe, and your compassion with that woman, and put her on a bracelet. And I think she posted 5,000 or something.
Turned in her passport too.
Turned in her passport.
She'd gone to China but had come back.
Right. Yeah. So anyway, I have experienced with you on that compassion issue, and you always have a great bit of compassion. Let me ask you a couple of things here. On the drug issue, we have, I believe, one judge in the entire court system, I may be wrong, one judge in the entire court system who is certified in drug addictions.
Wow.
In my view, I think it should be mandatory for judges to either go to some sort of training or become certified. He took a year's course in that effort to become certified as a drug expert. Addictions obviously play a great part. And I know at times I've even suggested to a judge to hold a client that I thought was going to probably end up overdosing or dying.
Well, who's that, Judge?
That's trust.
Thank
But, you know, I've had a lot of personal dealings with addictions and throughout my family members, and growing up in Holyoke as an Irish person in Churchill, where there was about 85 bars,
Yeah.
a lot of addictions. Yeah. I've learned one thing about them, though. Addictions always trump fear. Fear will never trump an addiction. You can threaten to put somebody in jail, hopefully to get treatment. But the addiction doesn't go away when they're released. It's still there. I knew one time in Holyoke, a police officer, last name was Kelly. His son was a friend of mine. And I've seen him recently, but he was from Ireland. And he was a very rugged man. And his brother was an alcoholic and wouldn't go home and support the family. And he took his brother into an alley in Holyoke, and he just about beat him to death. And one would think after that, he wouldn't pick up a drink again. And he threatened him to do it again if he ever did. He picked up a drink again. Some people are not able ever to stop an addiction, whether it be drinking or drugs. I don't believe we should treat them in the court system. Court system has been designed since it was made to punish. I don't believe in punishing somebody with a health condition, an addiction. Most people with addictions, probably all of them, got it, and the gene passed down to them. And that's my take on that. Let me ask you on this bias issue. Of course, no judge is going to ever admit to being biased in his decisions or her decisions. No police officer is going to admit to that. Very few people are ever going to admit to that. And I think that's why it's so hard to find out who has got this bias and uses the bias. Because there's always fallback, isn't there, in your decisions as to how you decide what to do. Well, I sentenced him because of this. I sentenced him because of his record. I sentenced him because of victims involved in the case. So you can kind of, whoever has the wherewithal to hold this bias, they can kind of cover it pretty well. Don't you agree?
I don't think there's any doubt about that.
Yeah.
Then the other question is, are they even aware of it?
Probably not. Probably not.
Yeah.
And I believe it's so systemic in our society. I don't think, I'm reading a book about this too, but I don't think we've ever come to terms in this country with slavery, with the black and white issue. You look at the Civil War fought, almost 600,000 Americans killed, all fought to keep slavery. Well, the wealthy Southerners who ran plantations and businesses. And right up until today, we see so many times a police officer shooting somebody in the back. In my view, once he's gone by you, your threat is over. To shoot somebody in the back, and we're seeing it played out. Thankfully, this thing is coming to a head. Maybe this will be the issue in the time of our society where we correct it. I know from my dealings with you and from other people that I speak to, you don't have a bias in your body as far as I'm concerned. On the issue of trials, let me ask you, what do you think of professional jurors?
A professional juror? I don't think I know what that is.
Well, what I'm thinking at is there's been discussions about it and written about it, but you hire jurors, you train jurors, you train them about biases, you train them about evidence, emotions. You give them a stipend and they sit in juries. And to me, the more I'm in front of juries, the more I kind of think that way, because as you well know, jurors can do whatever they want for any reason they want. They can find a guy guilty because they don't like the lawyer. They don't like the prosecutor. They can find people guilty for a whole lot of reasons why they shouldn't find somebody guilty. So it seems to me, at least, it might be explored as to hire people. You know, obviously they've got to be certified and they've got to go through all of these tests to see how they're going to do. And I just think that maybe we would get better decisions with the emotion out of it. And they knew what they had to show and prove. And because I know, like you do, sometimes you're trying a case to a jury and you got two people that are looking at the ceiling all throughout the trial. They're
Or
not even
asleep.
interested in the case,
Or asleep.
or they fall asleep.
There's a
And
whole
somebody-
body of case law that I'm sure you're aware of how to deal with that.
Yeah, but it kind of disrupts a jury, you know? And I just wanted to get your thoughts on a professional type system of juries.
I'd love to see those articles you mentioned. I am not aware of that.
Yeah,
I'd love to see those.
yeah, I'll get that information. Too.
Thank you.
It's kind of interesting reading, you know?
Yeah.
And you know, a lot of jurors, they don't want to be there.
No.
I mean, how many times people, I call them the sick, lame, and lazy, they come up to the sidebar. I can't sit, I got to do this, I got to do that. You
I
know?
used to tell, we'd greet the jurors, and Judge Ford knows what I'm talking about, and I used to say to them, you have already made a sacrifice. I think what's the old expression, 75% of life is showing up. Some of you had childcare issues, you had to get someone to cover you. You've already made a sacrifice. Thank you, thank you, thank you. I think if you try to come up with some words to uplift them, it's one of the most enjoyable things I used to do in the Superior Court, is to try to get their attention and thank them. They've already sacrificed for us, and remind them that they not only decide cases, they keep the peace. Because people who lose their cases, they're heartbroken, but they say, well, 12 unbiased people decided unanimously, and that even in civil cases, they don't usually riot. They don't resort to violence. You keep the peace as a jury. And I think you can get to them, but it's tough, but not impossible. It's not impossible.
Yeah, a lot of times, you go to sidebar in a jury, and I'm sure Councilor Kennedy's had this, where they say, when the judge says, why can't you sit?
Yeah.
I think he's guilty. I think he's guilty, just being charged. I was in a trial up in Lowell in the Superior Court where a probation officer, 20 years of probation officer, came up to the sidebar, said to the judge, I think if he's been charged, he's guilty. The judge bawled out the probation officer and said, you're going to sit on this, you go back to your seat. But
We used to say, you're excused, and then they'd say to the court officer, he doesn't leave till 4:30.
oh yeah, that's good, yeah. But the fact is, even when you put them back in the panel, if they get called, you as a defense lawyer, you don't want them on the jury. But, that's.
You're tempted to jump down their throat.
Yeah.
And you have to be careful. But I had a juror say that to me, and I knew the kid. And I said, so if you were arrested, we could skip your trial too and just send you to jail.
Mm.
And I was obviously giving him the needle. But I hate to let them go away without at least a little reminder.
Yeah.
And I said it would be illegal for me to put you on the jury. You're not entitled to serve on the jury. You're not qualified to be a juror. And then I said, well, I guess he doesn't really need a lecture from me, but I give it to him anyway. You're not qualified. I'd be breaking the law by putting you on the jury. You don't deserve to be a juror. It's a very
What do you think of the guidelines issue?
I never found them helpful. I used to say, and there's subject to interpretation. Well, Your Honor, the DA says the guidelines generate this one, and then the defense says, no, they generate this, and then the probation officer, no, you're both wrong, it's this. I just didn't find them helpful. And I remember I didn't even know they existed till I became a judge, and they're overwhelming. There's so many factors, and I just never found them helpful, and I'm quite sure I was never influenced by any of them.
Yeah.
Too much. It just was too much information. You had to be a math major to figure out, well, this is like, I just never felt them to be helpful, ever.
And my other complaint is, I don't get why the probation officer gets to chime in on. Now, most of the cases I had, they don't. The judge never asks the probation.
Yeah.
But there are some courts they do. There are some courts you got to take, if it's a district court, you got to take the sheet if you're pleading. You got to get approval from the probation department.
I know. Of course, many judges would call probation over and consult.
Oh.
And that, in my view, has to be on the record. The defendant needs to know what the probation officer is whispering in the judge's ear. If probation wanted to make I'd say, well, you need to say it on the record. And then I would allow the lawyers to question probation. The one area I found them to be somewhat helpful is if you've got a kid, I had a kid who was no criminal record, but he was speeding out in Greenfield down a country road, and he was going something like 80 miles an hour, because I didn't know this. Did you know your airbag cracks your speed for the last 5 seconds? I never knew that. And it was in the 80s, and he killed a beautiful young older woman. And I didn't know what to do with the kid. But he killed this woman. So I asked for probation to do what they call a pre-sentencing report. I just wanted to know more about the kid. But that did not include a recommendation. And if it did, I wouldn't have read it. I just wanted to know more about the kid.
Yeah.
You know, he actually wept on the stand, which impressed me. He wept for the woman he killed.
Yeah.
And I think but I did give him a year. I did. And I think he needed it in his own. I needed to feel he was punished for what he did. And it was a county sentence, so I'm sure he got out half time.
Yeah.
But that would be my only use of probation, to get one of those pre-sentencing reports. It's a lot of work. I'm sure you've seen
they used to do a lot more of them many years ago, and they were good reports.
Yes.
Some of them write excellent reports,
Yes.
but they wouldn't give a recommendation.
No.
Anyway, it's not. Counselor Devaney brought up the fact that some judges have been in one court, like the Superior went to the district. I know a district court judge at 40 from Concord, whose father was a Superior Court judge. He went from Concord to the Superior Court, and I think he sat up in the Superior Court about 12, 15 years before he retired. Didn't go through the council, didn't go through the governor to nominate him to that position. So I'm kind of glad it's being raised, because I think we got to kind of keep them on the level on those. Otherwise, they won't need us for doing things. They'll just transfer people that win whenever they want them. I don't have anything else for you. I was proud to vote for you the first 2 times. I'm proud to vote for you this time. You've been one of the best lawyers in Western Mass before you became a judge. Just well thought of by everybody that I've ever talked to about you. And I'm kind of glad you're back in the Superior Court. I know I said something to you when you were going I wish you wouldn't go to the appeals court, because I think the Superior Court, you can do a lot more for people than you can in the appeals court.
Every day.
Every day. And it's more of a social, you get to see people, talk to people, and do all of that. So I'm glad you're back, and I'm glad for the citizens out in Western Mass. They're going to go before you, because they'll be treated really decently, in my view, no matter what you sentence them or do. So I'm proud to vote for you. I'm going to vote for you. And if you come back again and want to go to the district court, I'm going to vote for you for that also. Thank you very much.
Thank you, Counselor.
My first question was, are you going to promise not to come back?
You know, I always say I'm not very good at predicting the future, so I don't even try.
I just have a couple of questions, but
Sure.
not very much. Dealing with the implicit bias issue, because, it's obviously one of the top 2 issues that we're facing in the world today, the pandemic and that. Do you think in the last 10 years there are people of color that would not have gone to jail if they weren't people of color?
I think the answer is yes. And I think even if you take something as minor as sentencing alternatives, much more prevalent now. And so I don't have any doubt that the answer to your question is yes.
I think there are people who've been arrested
Yes.
because they're simply people of color and for no other reason in the last 10 years I'm talking about right now.
I don't have any doubt about that.
How do we make up for that? How do we make up for those people that have, young people especially, that have felony convictions that are following for them for the rest of their lives? They can't get jobs. They can't get educations. They can't get financial aid sometimes to go to college. When it's because we as a society, we're all guilty to a certain extent.
I think creativity and vigilance. I know one judge who, when he was convinced that an injustice had been done, but the time to file a revise and revoke had surpassed, entertained a motion for new trial and granted a new trial, and then found him not guilty. I mean, that some people say is over the line.
Sure.
The judges should not be inviting lawyers to file a motion for new trial, because a motion for new trial can be addressed years down the road.
Right.
But I've heard of that. I know Judge Ponzer in the federal court was always complaining about the mandatory federal guidelines. And I wasn't the one who asked him this, but I wish I was. He said, well, why don't you entertain motions for a new trial? What's preventing you from doing that if you think an injustice has been done? And I don't remember his answer. I don't remember his answer. And he's a good guy, a really good guy.
But there are people, fellow citizens, fellow Americans, fellow human beings that have gone to jail, had their liberty taken away over I'm just talking about the last 10 years in our modern society that shouldn't have gone to jail. What do we do about all those people? What do we do about the fact that they have all these records that are, still somewhat the chains of slavery that's keeping them down? That and it really does, as Council Jubilo pointed out, go back to that time.
I think
what do
also,
we do about those people as a society?
I don't know. I think if an injustice has been done, somebody should try to right it. I know when I first came on the Superior Court, it was the first time that they took a look at eyewitness identifications in the courtroom.
Terrible.
It's gone now.
Yeah.
But I remember saying, wow. The first trial I had was a fellow in Holyoke. Testimony was a black guy in a hoodie came down the hill. It was a dreary, right near the canal. Pointed a gun at this guy, fired 5 times and missed all 5 shots. And then he took off. And the question was, do you see that man in the courtroom? And yeah, I do. And he said, who is it? It's the defendant. I said to myself, really? You're going to have, it was a dreary day. He was dark skin, a hoodie, and the guy's pointing a gun in your face. And you're going to be, I didn't believe it. It was a jury trial. I didn't believe it. Now, I think within a half a year, Creighton came on and said, we're not going to do that anymore. We're not going to allow those identifications. He's sitting right there. It's so obviously prejudiced. I said, really? There was no objection. And I don't know what I would have done if there was an objection because the law hadn't been established, but I didn't believe it for a minute. Right. And this has been going on and on and on.
For centuries.
Yeah.
Centuries.
And now it's not.
I don't know that Creighton has solved
and I
the
can
problem,
remember
but it certainly has come a long way.
When the study group was presented to the Superior Court, there was, oh, what do you mean? You're not good. One judge said, the jury wants to know whether you can stand up and say, that's the guy. And it was Bob Kane who presented it. And Dan can recall, he got a very rough time for even considering getting rid of eyewitness identification in the courtroom. And a year later, of course, then Creighton comes out and others come out. And Bob got up and he says, he got a standing ovation. And he says, I feel somewhat vindicated.
Yeah.
It was a great moment. But it was unthinkable that we were going to eliminate that.
Right. I appreciate the fact that both you and Judge Ford have recognized that the implicit bias exists, and as both of you indicated, you've looked inside yourselves and found it there and have tried to correct it over the years. I think that that means a lot. And I appreciate both the fact that you've done that and that you've acknowledged it. I hope some of your colleagues are doing the same. I'm going to be voting for you next
Thank you,
week.
Councilor.
And I can appreciate your comments about your daughter, Katie, because
Thank you.
my son is a nurse. And, he was
Yeah.
working over at the COVID Seaport Hospital. We had the same concerns.
Really?
So it's been a very difficult time. I'll be voting for you next week.
Thank you, Councilor.
Thank you, Judge.
Can I just add a point? I have worked with Councilor Hurley on recruiting minority judges, and I will tell you, I just want to leave you with this, if I may. You've got competition for these bright minds. We lose a lot of talented Latino and African Americans to corporate America.
Yeah.
They have more resources to boost their diversity number. We lose some terrific people. We lose people to the corporate America, to the big law firms. The big law firm, they don't get trial experience. And I know you're all about trial experience.
Right.
But they don't get a chance, and they deserve those good jobs and making a lot of money. Why, to get court experience is, you're not going to get it in the big law firms. You lose that. And the other one is government. There was a African-American trial lawyer in Springfield City Solicitor's Office. I'm not going to mention his name. I'll tell you privately if you want. I said, this kid's going to be a judge. He's a great lawyer. He's African-American. He's on his way. Well, he got another job in government that paid him a good salary, retirement benefits. It's tough for young minority people to turn down great jobs in government. And I said, we lost that guy. I told Mary, he would be a judge someday. So they get better offers, frankly.
No, I understand that.
And
That's-
trial experience, I know, but there are some terrific minority lawyers who would make great judges, but they haven't had the opportunity to get the trial experience. So
Right.
I know why you want to see that. I know it's important, but we all know very good judges who did not have a lot of trial experience. Every one of us know that.
I haven't met those yet.
I'll give you some names.
But no, I agree with that I've run into the same type of issues as I've been trying to reach out.
Yeah, corporate America's way ahead of us, and
Yeah.
they're making great offers, and these kids are accepting them.
Right.
And the big law firms.
But I still
They're
think
scooping them.
I still think we have to fix it.
After what?
Fix it. And we have to fix the issue of
Yeah.
not enough women in the Superior Court. As I'm sure you are aware, I'm sure Judge Ford's aware, the percentage of women in the Superior Court has gone
Yeah.
dramatically down
I know.
recently. And it's going to go further down in terms of, there's going to be some retirements. And we got to fix that as well.
Thank you.
Okay, and thank you.
Mike, can I say one?
Sure, of course. Councilor
Just, I want to just leave you with one thought. If anybody doesn't think we have a lot of work to do on racism, we're not a racist country. The Black population is approximately 16 to 17%.
Yeah.
People behind bars, 50% of them are Black. 50% throughout the country. I think that says it all.
Every
And
time
I
I
read
walk
that-
through the courtyard at the Ludlow facility, you just, it almost like, sounds crazy, but for the uniform, it looks like a college campus, all young and all dark-skinned.
I also read
For the
that
most
something
part.
like 64% of the stops in Boston were African Americans. Yeah, I read that the other day. So it's fun. Okay, we're going to adjourn. Thank you, Judge.
Thank you all.
You'll be
Thanks
back,
very much.
you'll be back to work in the trial court in 2 weeks, I'm sure.
Thank you very much.